Good morning, everybody, and thank you for making the effort to come at this early hour. It's still winter, although it's not quite as dark or as bleak as it has been earlier in the season. This is a particularly useful topic, it seems to me, because of its wide range of appeal and application to such a variety of legal practitioners. It's not only of interest to the IP specialist, but it is a recurrent topic, I imagine, for general practitioners, because trademarks have become such a pervasive part of commercial activity. One only has to walk into this building and see the sign Owen Dixon Chambers on the front of the building, and underneath that is the subscription TM to indicate that it's a registered trademark. So that's an indication of how pervasive that species of intellectual property has become. We are fortunate to have three experts to lead us into the intricacies of this topic. The speakers have divided the topic into three parts. The division is logical, but it's not completely self-contained. There will be some overlap between the areas considered, and I'd ask you to keep your questions until each of the three speakers has finished his presentation. We'll then take a break for coffee, and there'll be a panel discussion at which your questions can be raised, and any that occur to members of the panel as they listen to the other speakers, and we should conclude the session at about 8:45. So the first of our presenters today is Simon Minahan. Simon is a commercial lawyer with a particular emphasis on intellectual property and insolvency. He has a master's degree in intellectual property and information technology law, and he advises and appears in all jurisdictions in that area. He's advised extensively and acted as a consultant on the supply, implementation and licensing of intellectual property. He's advised companies, entities, including government departments, large corporate as well as medium and small scale software and application providers. He's also had a long-standing practice in insolvency and bankruptcy law, and has been an experienced litigator as well as mediating in corporate and commercial law disputes and trade practices matters. He's a member of the panel for the WIPO Arbitration and Mediation Centre, which is concerned with the arbitration of disputes about domain names. So with that introduction, I'd ask Simon to make the first presentation, which will cover the question of applications for trademarks.
Thanks. Good morning. Now, if I might, I've worked under the assumption that most of you here have some acquaintance, but only indirect or occasional acquaintance with trademarks and processing. Is that a fair assumption? I don't think we're dealing necessarily, and I think the general picture of this is better for the general practitioner rather than for specialist practitioners. So, on that basis, we're doing a bit of an overview from first principles. If some of that's a bit too familiar or obvious, simply apology now, but we think it's probably the easiest way to proceed. I'm going to discuss just broadly what's involved in an application and why one would do it and what one looks for, and we'll then be looking at the grounds which the examination considers as to whether an application will be accepted or rejected, and then Chris will be discussing how an opposition, how someone may oppose an application before it's finally registered. So, in line with that, I thought we'd start with just a consideration of what is a trademark. And the first thing to observe is, while we're discussing the registration process this morning, as I'm sure all of you will be aware, a trademark can exist without registration. It's a common law recognition of and protection of trademark interests of reputation in trading identity of a person or a company. And in that wise, a trademark in either system is a sign which is used in the course of trade which identifies the source of a product or services, or in the language of the area, which distinguishes the goods or services of one trader from another. In terms of a registrable trademark, it can be a letter or a number, a word, phrase, or a logo, which are the more common aspects, but it can extend to a sound, a shape, a smell, and contentiously difficult to get to appear, a colour, or an aspect of packaging, or a combination of any of these things. So its potential range is very broad indeed, so long as one can justify that it is a characteristic used to identify a given product or goods, and one sees many different examples of it. One of my favourites, I think, is bananas that come from Queensland, I suppose, but a grower in Queensland that are dipped, one end is dipped in wax and they've got a red tip. That's just a classic and simple trademark, but not what you would consider the obvious or standard. Intel has the sound of 5 notes, which is covered by a trademark. We're all familiar with the Cadbury and Darrell Lee arguments over the years about the colour purple. So, if and when you're considering these issues for a client, it's well to bear in mind that there is great breadth available there, although it may be bold to try and evade yourself entirely of it. You need to be conscious of the difficulties, the wider you go, if you like, in the spectrum. So that's the first thing. The next concept for a trademark to be registered that you need to turn your mind to is the notion of it being inherently adapted to distinguish, which runs through the application process and the assessment the Office of the Australia has to make in dealing with an application. And I think that is again a spectrum where it's useful to consider it from perhaps the perspective of something like a fancy word, as though known, a fancy mark, where it's an invented word like Xerox or Kodak, that wouldn't and doesn't carry any particular meaning at all. That is naturally and deeply inherently adapted, as the phrase goes, to distinguish a trade, because it doesn't have a meaning that would otherwise be used in the language or other people would want to use. At the further end of the spectrum, more generic or descriptive terms or names of products. Those are generally not regarded as adapted to distinguish, and it will be much harder to obtain a registration for. Where something's inherently adapted to distinguish, then other criteria being met, you're going to get a registration so long as there isn't someone already in the space using something similar or the same. Where you don't have an inherent adaptation, where it's a word or a phrase or something that traders might ordinarily want to use, you may be able to establish the basis for an application by use, by proving that you've made use of it, and in particular use of it as a trademark. So that's a consideration, as I say, when you're looking at all variety of designations, but also whether or not in a given circumstance a word like apple, which has no real relationship to records or to computers, is inherently adapted to distinguish, where the word camera for selling digital cameras, for instance, would likely confer all sorts of issues. It's also important to note that while use confers rights in a trademark, forms of registration other than trademark registration do not confer trademark rights. So corporate registration doesn't give you any particular rights in the name of the company, neither does business name registration, neither does domain name registration. Domain name registration has qualifications which might disentitle you if you lack a trademark interest ultimately, but it's not a prerequisite and it doesn't confer any right to actually apply and just obtain it. The key to all trademark rights in the end is going to be use or intended use of the mark. So a trademark is, as we say, a sign of some sort that is going to be used or is being used to distinguish your goods in trade or commerce. So if we can have a common law without expense, and it's recognised and protected, why register at all? And that'd be a question you might certainly want to be able to answer for your clients and advise them why. And there's a number of aspects that flow from registration. First is that you are in a public register and constructive notice of your ownership is out. And there's a presumption of ownership of the mark once registered that follows. Perhaps more practically, there's a presumption and an advantage in evidence if you come to take infringement proceedings that you have a reputation as a mark, whereas with the common law trademark, you have to prove that. If you don't, you have to put in that evidence, you have to run it, you have to establish that you have a reputation in the word or picture or whatever it is as a trademark, which merits protection. That's taken as read once you have a registered mark. You have the benefit too of the register in as much as there are provisions that say you're entitled to deal with the mark as it shows in action subject only to interests that are noted on the register. So it gives you some commercial advantage there. It provides a good basis for international registration using the Madrid protocols or other systems if you have a registration, so that you can have more orderly and deliberate commercial expansion internationally. And it also gives you access to the resources of the border authorities, customs, by giving them notice of infringing goods if you think there are goods that are being imported in the country, they can be seized. And, so you can put the armoury of the federal government to work in protection of your trademark, which you can't do if you're not registered. So there's a suite of reasons to do it. Who may register a mark? The answer is, in the 1995 Act, the owner, which goes undefined, very helpful. But so it begs the question, who's the owner of a mark? Or at least invites the question. Well, in fact, so the owner can register so long as they either are using or intend to use the mark in relation to goods or services, or have authorised someone else to do that, or are in the process of setting up a company to do that. So actual use is not required, so long as there is a genuine intention to use within a stipulated period, and if you ultimately don't use it, then you can be liable for the mark to be expunged for non-use. But it still leaves the question, who's the owner? And one's forced to look at case law in that, in answering that question, and it's a raft of considerations about authorship, if it's an expression that you've come up with, or a logo or an image, that will be a factor. Prior use, who's been using it as a trademark, will go to the question. And it isn't necessarily a matter of originality. I mean, you can, it is legitimate, even if a little sharp, to register, for instance, a name you've copied from an overseas company in Australia if they're not already here and have a presence. But if the overseas owner were to object, they would need only to prove very slight evidence of use in Australia to push you off their mark. But first use in the jurisdiction, coupled with questions of authorship, authority, if any's been given, none, are the questions you need to consider when you're sitting there with the client deciding whether or not they're in a position to, or have standing to, file a trademark application. And the timing of making an application keys off that analysis as well, since you need to be committed or intending to make use of the mark within a reasonable time, or you're going to face some difficulties. So, you then need to consider the space that you're entering. What do you register for? There are 45 classes of goods and services, 34 of goods and 11 of services. There are tools, and IP Australia's website is the starting point for all this inquiry. They have a database there of registrations and applications which can be searched. So you need to undertake a search to see if someone else is already using that mark or a similar mark for similar goods and services. As the website will tell you, that can be a bit of an art in itself, that search. It's not necessarily a straightforward proposition. And I know they run courses in all the states on how to search. If you think you've got enough potential work to justify it, you can run 2-day courses for about $1,000. But you can also scour it yourself, and you can obviously enlist the help of a trademark attorney as a sort of an outsourcing proposition. But there's also now a new process which they call Head Start, which is divides your application into 2 parts. In the first part, you pay a fee for each class that you want your particular mark to be registered in, and the office undertakes a preliminary survey of the space and what you're registering, and within 5 days it gives you a bit of feedback about the likelihood or otherwise what difficulties you might face. And then you can decide whether to proceed from that to a registration application, pay a second round of fees, and off you go. Your application only commences when you pay the second round of fees, but it is it's certainly worth considering because it's useful to enlist the expertise of the office itself in giving you an assessment of whether or not your application is flawed or got reasonable grounds. So formally you need to make an application that conforms with the office's requirements. You should have a representation of the mark which clearly identifies it, and it should be in graphic form, even if it's a sound guide or a scent, or you need to be able to represent it graphically. There are some guidelines about how that can be done. You've got to specify what goods or services it's sought for and in what classes, and include your particulars of your applicant contact details. And again, if you look at the website, there's a trademarks Office Manual of Practice and Procedure, which is a bit of an anachronism, but in the title. But it's the manual that they use to process, and it's available online on the website. And I think it's section 6 covers applications, and there's a lot of useful information addressed there, and we don't need to address here, but be aware of it. It's a very good resource for you. Once you've applied, and your application is published, it's very difficult to amend. You can't add to your application, you can't add new classes or products, you need to make a separate application. You can reduce it by what's called a divisional application. You can carve a bit out, but you can't enlarge it really. And then the Trademarks Office will examine and give a report, generally in a couple of 2 months. The fastest you can get to a registration would be 7.5 months. And the report involves an examination looking at the grounds that it might be rejected on. If they don't find such grounds in your application otherwise meets the requirements, the formal requirements, there is a presumption of registrability, which means you will get your trademark registration. And Andrew will tell you more about the examination process and the grounds. Essentially, that's, I think, all I need to say to you about the process. IP Australia has all the detail you need and the fees. It's $120 a class, I think, if you do it online. So it can add up if you do a lot. There's always a balancing act between how wide you go, how many classes, because there's a cost, but you're also maybe not going to be using them, so you're exposing yourself to non-use applications. But you can't enlarge it. So you have to take pretty good instructions and think about, I think it's very sage to concentrate on what is it that's going to make money, because the trademark application costs money to lodge and to maintain and to police. So there's not much point in registering for things that aren't essentially commercial. And I'll hand over to Andy.
Thank you, Simon. As I said at the outset, there is necessarily some overlap between the topics which our presenters are to cover. The next topic is objections, and Simon has already touched on the fact that objections may be lodged to an application, and he specified particularly the overseas owner of a mark may object to an application in this country, even though there's been no prior registration and possibly no use of the mark. Next presenter is Andrew Sykes. Andrew has a practice in intellectual property and commercial law, including trademarks, domain names, passing off, misleading conduct, consumer protection, trade practices, copyright, designs, internet law, and confidential information. Before coming to the bar, he worked in the National Trademarks Group and the domain name disputes group of Griffith Hack, which most of you will know, the leading law firm in the area of intellectual property. And he, in that capacity, managed trademark and domain name portfolios for a number of clients. He appeared in opposition proceedings and advised in-house counsel on various areas in those fields. He's also been engaged in domain name arbitration proceedings in various jurisdictions for large corporations, some of them international resources companies. Since coming to the bar, Andrew has represented clients in the Federal Court and the Trademarks Office in Melbourne and Sydney. He continues to advise on complex issues of trademark registration, opposition and infringement, and assists other trademark attorneys, intellectual property solicitors, and has also appeared with senior counsel in those areas. He's been the author of a number of articles in professional journals and is the author and web designer of the online publication Australian Trademark Opposition Law, and the site for that is www.oppositionlaw.com.au. In addition to his specialist practice, Andrew has practiced generally in the commercial area, particularly in consumer protection and contract. He's been an active member of the Law Institute of Victoria's Intellectual Property and Information Technology Committee, and he recently represented the Institute in its consultation with the Victorian Government on that government's new policy in relation to the management of intellectual property. So we'll wait with some anticipation Andrew's presentation on objections to trademark applications. Thank you.
Okay. Thank you, Don. Well, as Simon explained, once your application is filed, it's examined by an examiner in the Australian Trademarks Office, and there are a series of objections that the examiner can raise to prevent the application from proceeding to acceptance. And those objections will be put in an examiner's report sent out to the address for service, or the person listed as the address for service for the application. So if you've done your client's application for them, you can expect the examiner's report to come out to you. Now, the grounds for the objections listed in that report will be based on one of the sections between, or one or more of the sections between sections 39 and 44 of the Trademarks Act. Now, those grounds of objection can really be split into two groups, which I think helps you deal with them more easily. The first group of objections are objections to marks that simply cannot be registered, such as marks that would be unlawful to use because they contain a graphic element that infringes another person's copyright, or marks that contain signs that are prescribed as being unregisterable by the regulations, such as the word ANZAC or the coat of arms of the government, marks that contain scandalous matter, such as profanity, and marks that are inherently deceptive or confusing. And to give you an example of a mark that's inherently deceptive or confusing, if you were to go register a trademark that contained the word digital, and you were to seek a registration for analogue televisions, there's a good chance the Trademarks Office would raise an objection and say, well, hang on, if you use that mark out in the marketplace, people are going to think that your televisions are digital televisions when, in fact, you're seeking a registration for analogue television. So it's an example of that. Now, the second group of objections are objections where the office doesn't say the mark cannot be registered, but what they say is essentially the mark cannot be accepted for registration at this point in time unless you provide us with further information or evidence. Now, the objections I'm talking about here specifically are the objection under Section 41 of the Trademarks Act on the grounds that the mark fails to distinguish the applicant's goods or services from those of other traders, which Simon touched upon, and the objection under Section 44 of the Act on the ground that the mark is substantially identical or deceptively similar to an earlier application or registration, and both marks relate to the same or similar goods or services or closely related goods or services. So just to take that back one step, you would receive a Section 41 objection if, for example, the mark consists of words that other traders are going to want to use in relation to their goods or services, maybe to describe the goods or services or a characteristic or function of the goods or services, and therefore the mark would not be distinctive of your applicant's goods or services because others would want to use it in that descriptive capacity. And you would receive a Section 44 objection, a similar mark objection, if firstly the mark is substantially identical or deceptively similar to the earlier mark, and both marks relate to the same goods or services, or similar goods or services, or closely related goods or services. Now, these two types of objections, the distinctiveness objection and the similar mark objection, are by far the most common form of objection that you're going to receive. In my experience, they would account for over 90% of the objections I've dealt with that have come from the office. They are by far the most common, and the good news is that there are ways of dealing with these objections and progressing the application through to acceptance in many instances, particularly if your client has already gone out in the marketplace and developed a reputation in the market. Because as Simon said, we have a, sorry, excuse the pun, I didn't mean that's what Simon said, but anyway, that was unintentional. But as Simon mentioned, really we have a trademark system that's based on use. The first person who uses the owner, the first person to develop a reputation. Okay, and that flows through the registration system as well. So it'll be of great assistance if your client has already been out there using the mark. And the options for overcoming a Section 41 distinctiveness objection are really limited to providing evidence that establishes that your client's mark does in fact distinguish its goods and services from those of other traders out in the marketplace. And that can be established, for example, by providing evidence of use out in the marketplace, evidence that it has developed a reputation in goods or services. Or the other main option for overcoming a Section 41 distinctiveness objection is to really put in written submissions right to the office and say, look, there are these legal grounds on which this objection ought not be applied. We therefore request that it be withdrawn and the application be allowed to proceed to acceptance. They're really the two main options. There's a third option which is very rarely used in relation to Section 41 objections, which is that in some instances you could limit your goods and services so that the objection no longer applies, but practically that option is going to be open to you on very rare occasions, because normally the reason that the client has received a Section 41 distinctiveness objection is they have overtly described the exact goods or services for which they want to use the mark. So trimming the goods or services description is going to be of not much use. Now, the options for overcoming a Section 44 objection, well, there's a lot more of them than there is for the Section 41 distinctiveness objection. So your first option for overcoming a Section 44 similar mark objection is if your client is able to provide evidence of prior continuous use, then they will be able to overcome that objection. And by prior continuous use, I mean that the client is able to show that it has used its mark continuously since a date prior to the priority date of the conflicting application or registration. However, if your client cannot establish that, your client also has the option of establishing honest concurrent use. And what that means is that they can establish use that they have honestly and concurrently used their trademark at the same time as the existence of the conflicting mark, and they have done so without instances of confusion, and indeed, if they're allowed to use and register the mark, it's unlikely that confusion in the marketplace will result. Your next option is you can simply seek the consent of the owner of the similar conflicting mark and seek their consent to your client's use and registration of its mark. Now, interestingly, in almost all circumstances, a letter of consent will overcome a Section 44 similar mark objection. The only real circumstance in which it won't is when there's a greater public interest in there not being two similar marks on the register. And when I say a greater public interest, the only example I can really think of is pharmaceutical goods. If you have two pharmaceutical goods that are known by the same trademark, and they're both being used by different traders in relation to drugs, there's an obvious public policy problem there, because this drug might be used, to have this effect on the body. That drug might be used to have a totally different effect on the body. So there's a real public interest and a safety issue. And the Trademarks Office won't allow those two similar marks to exist on the register. But apart from that limited situation, I really can't think of circumstances in which a letter of consent would not suffice in overcoming a Section 44 objection. And often those last two options that I just mentioned are actually used together quite cleverly. I moved on one step there. I've got to explain the next option to you. The next option is actually the more interesting option from a barrister's point of view, is that if all else fails, you can attack the prior registration if you have grounds to do so. And Simon mentioned before the issue of non-use. So if the owner of the prior registered mark has not used its trademark in a set period of time, you may be able to seek removal for non-use. You may be able to seek cancellation on certain grounds under the Act. Yes?
Is that non-use in a particular category, or does it matter whether...
Non-use in relation to the goods or services. It can be a partial application for removal from non-use. In other words, it could only apply to some of the goods or services, or it could be a whole application for removal, which is removing the whole mark. What I broke into before, because I just glanced down at my notes, which is why you shouldn't rely on notes too often, is that option and the option I mentioned before about the letter of consent. Those two options can often be used together. In other words, you can often write to the owner of the prior registered mark and say, well, you've got these issues with your registration, and we may seek removal or cancellation of your mark, but really all our client wants to do is progress its application through registration. So how about you just give us a letter of consent and we'll all move on. And that's quite effective if done diplomatically in many instances, and a cost-effective way of getting the application through. The other option you have in relation to overcoming Section 44 objections is you can limit your client's goods or services, as I mentioned in relation to the Section 41 objections. That's much more commonly used in relation to Section 44 similar mark objections, because as I explained, not only must the marks be substantially identical or deceptively similar, they must also relate to similar goods or services or closely related goods or services. So if you cut your client's application so that these goods and services no longer conflict with the earlier application or registration, the Section 44 ground for objection disappears. And of course your final option is also you can put in legal submissions as with any other form of objection and argue that the objection ought to be withdrawn if you believe there's grounds to argue that. So that's what you can do I'm sorry if I'm speaking fast too, I'm just conscious of the time. That's what you can do to overcome objections. Really the next important point and practical point is how do you go about it. Now what you must remember when you're dealing with these objections is with the Trademarks Office, you're dealing with examiners who operate in a team environment, generally with a more senior examiner as the head of the team. Those examiners are required to examine many applications a day in order to meet their internal quotas, because they have quotas just like law firms. And in order to do this tough task, they need to apply the law, and they also need to apply office policy. And that's an important point. They can't just go to the Act every time and look at these broad sections and exercise their own discretion in any way they see fit. They don't have time to go reading all the federal court decisions, so they have to rely on office policy. And the office policy is expressed in the examiner's manual, which Simon mentioned earlier. Now, the issue that can occur is, as you know, with many areas of law, sometimes the application of policy in order to try and help an administrative body deal with things in a consistent way, sometimes that application of policy can lead to the incorrect legal decision in many instances. For example, a trademark for common services, which consists of a geographic place name, will often be objected to by the examiner. They'll often pick up on this issue in their examiner's manual, and they'll raise a Section 41 objection. The reason they do that is they say, well, hang on, you're applying for this trademark for this, these common services, and it consists of a geographic place name. Other people in that geographic place are going to want to use that mark for their goods or services that they provide in that place. So they'll apply the Section 41 distinctiveness objection. And often, 90% of the time, 99% of the time, they'll do that correctly. But I did have a client some years ago who sought to register a trademark consisting of the word Glastonbury in relation to counselling services and psychology services. And they put in their application, and sure enough, they got an examiner's report. And the examiner said Glastonbury is a geographic place in Queensland, and therefore other people who are from this place ought to be able to use that word to describe their own counselling or psychology services as coming from Glastonbury. Now, has anybody here heard of Glastonbury in Queensland?
No.
Right, there's a really good reason why you haven't heard of Glastonbury in Queensland. I did a bit of research when I got this objection, and it turns out Glastonbury is an area of bushland 125 kilometres out of the CBD of Brisbane, and it has an approximate population of around 200 people. So the chances of there being one of those 200 people who also wants to set up psychology and counselling services is just really remote. Unless they're going to set it up in the back paddock, it's not going to happen. It's literally bushland. There's no towns, nothing. It's just an area. So I pointed this out to the examiner, and the examiner rightfully withdrew the objection, and the application was allowed to proceed to acceptance. But the important point here is that you can't just take the examiner's report all the time at face value. You need to do your job as a lawyer or as an attorney and have a look and see whether the objection has sufficient grounds to be maintained. Because in many instances, if you deal with a lot of applications, in many instances you'll find that there are grounds to say the office has got it wrong, or the office has misinterpreted on this particular issue, or they've applied the manual in an incorrect way, which has led to a funny sort of decision. And that can provide, that can create tension between between you and your client as well, because you've said to the client, oh yeah, I think this will be fine, then you get this objection. But what I would say that you really should do is have some empathy with the examiners. You don't want their job. They have to examine, as I said, multiple applications every day, apply policy in order to do that, because it's the only way you can get it all done. They don't have the pleasure of a federal court judge who can sit there for a couple of days looking at 2 or 3 issues in relation to one trademark. They don't have that luxury. So have some empathy, deal with it in a constructive way, and you'll often get a good result by working with the office rather than against them. Now, finally, before I hand over to Chris, there's just one last issue I wanted to mention. When you receive your examiner's report, you will see that there's a deadline on that report by which you need to have the client's application in order for acceptance. And that deadline will be 15 months from the date of the first examiner's report. So it's quite a long time. But there are 2 important traps that everybody falls into if they're not used to dealing with these reports. The first is, that is a deadline by which the application must be put in order for acceptance. It is not a response deadline. If you go and put in a response to the objections only 2 days before that deadline, the deadline's going to pass, because you've got to take into account the office actually needs time to look at your response, look at your written submissions, look at your evidence. They then need to decide to accept the mark, or they need time to write a further report to say there's these deficiencies, and then you need time to respond to that further report. So I'd suggest that you don't let, and express this to your clients too, don't let them get anywhere near that 15-month deadline. If you think that the 15 months may not be enough, in certain instances there will be grounds to basically freeze that deadline, or what they call defer that deadline, particularly if, say for example, you have a court action happening in relation to an earlier conflicting mark or something like that. So be aware of that option, or alternatively you have the option of applying for extensions of time. And if you're going to do that, do it before the deadline, because it's hell to try and get an extension once a deadline's passed. And it's the kind of thing that I've been briefed to do specialist advice on, because it can get really messy. Yeah, that's all I want to say about objections. So, sorry, pass back to Don.
Thank you, Andrew. The final presenter this morning is Chris Doidge. Chris is going to deal with the topic of oppositions, and he has had a very strong background as a professional scientist before turning to the law. He's been a microbiologist, a project leader and a manager with the Commonwealth Serum Laboratories for more than 25 years. He's managed an intellectual portfolio which has been successfully licensed for more than $20 million, and in the course of that activity he was awarded the Young Tall Poppy Award from the Australian the Australian Intellectual Property Society. Before signing the bar role, he completed the degree of Juris Doctor at the University of Melbourne with first-class honours average, and awarded the Dean's Award for the student placed first overall in the course. Not surprisingly, he also obtained a number of individual subject awards in the course of that, of obtaining that degree. He also has a Bachelor of Science from Melbourne University, a Master's degree in Biotechnology from Monash, and an MBA from Deakin University. His scientific career focused on human and animal vaccine development and biopharmaceuticals. Following the discovery in Australia by Warren and Marshall of the bacterium responsible for peptic ulcers and gastric cancer, a discovery which many of you will know attracted or obtained for the inventors a Nobel Prize. Chris became a project leader at CSL in the development of a vaccine against that bacterium, and that involved collaboration between scientists in Australia, Sweden and the United States. And he was the lead inventor on a patent portfolio developed during the project. His managerial interests and experience focused on the commercialisation of Australian biopharmaceutical research. So with that unique background in another discipline, Chris is particularly well qualified to conclude our presentations this morning, and I'll hand over to him without further delay. Thank you.
Thank you, Don. So now on to trademarks and trademark oppositions. Thanks, Andrew. Pre-grant opposition is supposed to be a quick and cheap and efficient way for a person to contest a trademark application that they think should not be on the register. This is in comparison to taking action in the federal court to have the trademark revoked after it has been registered, after it's been put on the register. This is a good time to be talking about oppositions and not so good time to be talking about oppositions. It's good because a new act, briefly called the Raising the Bar Act, has come into force, most of it on the 15th of April, and has made significant changes, particularly to the process of oppositions. It's not so good a time for exactly the same reason, that there's not been much experience, practical experience with the new Act yet. But it's a good time to go through the new provisions of the Act. As I say, the new provisions have retained the pre-grant opposition process, and there was some thought about whether it should be discarded or not, but it's been retained. But it has been changed to try and fit in with that objective more closely of being a fast, efficient, quick, cheap process. I grew up in New Zealand, and when my father used to take us into the mountains, his mantra was, the pace of the party is the pace of the slowest. And that was something that was often applied to trademark oppositions. It often suited one party for the process to be slow, and sometimes parties would compete to see who could make the situation the slowest, the opposition process the slowest. But now the pace of an opposition is definitely the pace of IP Australia, and it will set pace, and it will be difficult to change that. So the idea is that it really will be faster and quicker. The opposition process really consists of three parts. There's an initial documentary phase, then there's an evidentiary phase, and then there's a hearing phase. And I'll have a quick look at each of those three different phases, and particularly looking at the changes that have been brought into those three phases by the Raising of the Bar Act. You might get an opposition because you've assisted a small trader with their trademark, and somebody might be opposing it, or you might have a client who wishes to oppose a competitive trader's mark or something like that. In terms of general practice, large IP firms, of course, have watching briefs on the Trademark Journal and are always looking out to protect the larger trademarks, or the trademarks of their larger clients. The grounds of an opposition can be usefully classified into two groups. There's that group of grounds of opposition that Andrew was talking about, that the trademark examiners could have used to object to a trademark, and as an opponent you get another go at those. So they are Section 39, use of prohibited or prescribed signs, Section 41, that it's not capable of distinguishing, Section 42, that's scandalous or contrary to law, Section 43, that there's some connotation that's likely to mislead or deceive, or Section 44, that it's deceptively, substantially identical or deceptively similar to a mark that's already on the register. But you also get another set of grounds that you can oppose the registration of a trademark on. And these are really grounds that the examiner is not likely to have had information to use during the examination process, but an opponent might. And these grounds can be split into two categories also, really. There's a section of ones that are related to ownership of the mark, whereby the opponent is really claiming that they own it, whether it's registered or not, and conflicting trademarks is the second major ground. So there's Section 44 and Section 60, Section 44 for registered marks previously, and Section 60 for unregistered marks. The ownership grounds grounds 58, 58A. And section 41 often also rears its head again, not capable of distinguishing, although you might have gone through that with the examination. The opponent can often have a go at that as well. The first stage in the old process was for an opponent to file a notice of opposition, and the opponent had 3 months after the acceptance of the application, which is the end point of the process that Andrew was talking about before. So if the examiner is happy, then the application is accepted, and that acceptance is advertised in the Australian Official Journal of Trademarks. And if you happen to be reading that continuously, then you'll notice it. And you had 3 months to put in a notice of opposition. Now that's been split up into 2 documents. The first document is a notice of intention to oppose, and that has to be filed 2 months, within 2 months of the advertisement of the acceptance of the mark that you're opposing. That deadline is going to be difficult to extend. The only grounds for extending it are going to be that there's an error or omission by the potential opponent or their agent, that IP Australia has made an error or omission, or that there are circumstances beyond the control of the potential opponent. And those grounds are going to be fairly narrowly construed. It's not going to be easy to get an extension of that deadline. Within 1 month of lodging the notice of intention to oppose, the opponent has to lodge a second document, which is a new one, hasn't existed before, which is a statement of grounds and particulars. Previously, you had to lodge, in the notice of opposition, you had to state which grounds that you were opposing the trademark. And commonly, people took a tick-a-box approach to this and ticked them all off because there was really no reason not to. There was no penalty, and you could decide later which ones that you really wanted to press. This was considered to be one of the causes of inefficiency and waste of time and resources in the old process. And now you're required to state which grounds you're going to oppose on and particularise those grounds. And if you don't particularise those grounds, you'll either be asked to, or the grounds will be struck out, or possibly the whole opposition will be struck out in that order. But most likely you'll be required to particularise. So you won't be able to just tick a box, pick the whole lot. You have to decide it fairly early on which grounds you actually have evidence for, which ones you're going to particularise, and which ones you're going to collect evidence to support. The next, actually a point related to that, in the old days you were required to serve these on the applicant. You now no longer need to serve these on the applicant. IP Australia will do that for you. You now need to file them or lodge them with IP Australia. And as I say, if IP Australia doesn't consider that the documents the grounds that you've chosen are properly particularised, you may get them back again, or you may risk them getting knocked out. Take-home message about the notice of opposition, because the 2 new documents together, the notice of intention to oppose and the statement of grounds and particulars together, are called notice of opposition, like the previous notice of opposition, but now they're 2 documents rather than 1. They're going to be hard to amend. The general power to amend under Section 66 doesn't apply to a notice of opposition. You now have specific rights under the regulations 511 and 512 to amend both of those documents, but the registrar can only grant a request to amend a ground of opposition or add a new ground of opposition if it relates to information of which the opponent could not reasonably have been aware at the time of filing. So it's going to create just a little bit of a difficult situation now, because sometimes grounds will appear on the basis of, for example, information that you get from freedom of information request about the application, and you will take a while to get that, so you won't have it at the time. But if the information to support a ground was available at the time and you chose not to rely on it, then it's going to be difficult to amend it later on. So the really take-home message is that it's going to require more care and thought and preparation at the very beginning stages of an opposition than previously. Now, the next step is another new document. It's a notice of intention to defend, and the applicant is required to file that within 1 month of receiving the statement of grounds and particulars. In the old regime, an applicant might do very little, might not intend to defend the mark, but the opponent still had to go through the process and prove that the mark could not be registered, and that was also considered to be a waste of time and resources. So now an applicant has to, an applicant for trademark has to deliberately choose that they're going to defend their application. After they've filed that, then that's the end of the first phase, the documentary phase, and you go into the evidence phase. The evidence phase is a bit similar to previously in that there are 3 stages. The evidence in support of the opposition provided by the opponent, and the opponent has 3 months to file that evidence. There's evidence in answer to the opposition, which is provided by the applicant, and they also have 3 months to do it, and the evidence for the reply, which is now 2 months. The 2 big changes are there was previously provision for further evidence, which was often taken advantage of, and there's now no reference to further evidence in the Act and the regulations. Secondly, it was very common and very easy to obtain 1 or 2 3-month extensions for filing evidence, and commonly done. It's now going to be much more difficult to get an extension for filing evidence, and the registrar may extend the period only if the registrar is satisfied that the party has made all reasonable efforts to comply with all the relevant filing requirements of this part, and despite acting promptly and diligently at all times to ensure the filing of the evidence within the period, is unable to do so, or B, there are exceptional circumstances that justify the extension. And 3 examples of exceptional circumstances are given: circumstances beyond the control of the party, an error or omission by IP Australia, or a court order. So the bottom line of that is that it is going to be difficult to get extension. So now it's really going to go along the 3 months, 2 months pathway, and it's not going to be easy to extend that. There's no more service of evidence on the other party, similar with the documents, but IP Australia is really entering the information age now. It's going to use a electronic document management system called Objective Connect. So after the notice of intention to defend is filed, it will set up a shared folder on this electronic service, and the parties can lodge electronic evidence, has to be electronic now, directly into these folders, and it will become available to the other party when it's filed in the folders. Then IP Australia will notify people that it's available then. They now talk about giving documents rather than serving them, and under a new regulation 2.3, that giving can be accomplished electronically by the registrar, and you're taken to be given it on the date that the document is, on the date of the document that's made available electronically. The final phase is going to be the hearing phase, and there's really only a couple of changes to that. The first change is that it's the registrar rather than parties who will decide whether the opposition is heard on the papers or whether there's an oral hearing. I'm not sure how this will play out yet. I would imagine that if one of the parties wants an oral hearing, that there will be one, but it's an interesting change that they've specifically said that whether it's oral or written will now be up to the discretion of the registrar. And there's no real indication of what factors the registrar will take into account when they do that. The second significant change is now in the regulations as a requirement to file a summary of submissions for the opponent 10 business days beforehand and for the applicant 5 business days beforehand. And the regulations provide for cost consequences if those aren't complied with. The final innovation for the raising of bar provisions to the process is the introduction of what they call a cooling off period, which came from overseas, and Andrew tells me from his experience it's used in Europe, where the parties can apply for a 6-month cooling off period, which can be extended to 12 months to allow for negotiations between the parties, whether one party might agree to modify the trademark or sell it to the other or sell it in a license back. There's all sorts of creative possibilities. Negotiation stage was accounted for in the previous regime by allowing people extensions to various stages, like filing an opposition or so forth, and the office seems to think that was a messy process, and now it's introduced this cooling off period as a cleaner way of allowing that negotiation process. And then at the end of that process, the office decides whether the mark will be registered or not, whether it will proceed to registration, or whether the opponent has established one of the grounds of opposition, which is all you need to establish, in which case it won't be registered. And that's it.
Well, thank you, Chris, for that very practical survey of opposition. We're running somewhat over time, so I'd ask you to abbreviate the copy rate. We'll resume in about 3 or 4 minutes with the question and answer session.